everybody, Todd Snively with Ecom Elite, here to talk today about intellectual property violations. Yay! Right? I mean, a really fun topic. Not, okay? But the reason we're talking about it is because there's just so many misconceptions about Amazon and intellectual property violations. Sellers get a letter from Amazon saying that they've been accused of violating intellectual property, and they don't know what to do about it, right? Sometimes they are buying from a legitimate source. Usually they are. I say most people are buying from qualified and authorized distributors, or maybe even they have a direct relationship with the brand, and yet they still get these letters accusing them of intellectual property violations. Now, before I go much further, need to make it clear, not an attorney, not an accountant, can barely get dressed in the morning. Okay, so as far as actual professional legal advice, that's not what I'm giving. What I'm telling you is what my experience have been, what my professionals have told me. And the other thing I kind of want to do is put to rest some really bad information out there. Somebody made me aware the other day, there's this young boy, some kind of college dropout, thinks he's an Amazon expert, putting out some really bad information about intellectual property. And so I'm going to try to correct all of his misstatements also in this short video. So let's start first with why you're getting the email, all right? If you're getting that email, somebody has made a complaint. It could have been, usually it's the rights holder, okay? Let's just assume for a second that that's where the complaint is coming from. Somebody has alerted the rights holder to a product that you're selling that they don't think it's a legitimate product, right? Because that's the only reason you should ever get an intellectual property complaint is if you are doing something that would lead the brand rights owner to conclude you're selling something other than his product, all right? Now, even though that's a fact, a lot of people misuse this whole intellectual property process. And that one kid I referenced earlier that really doesn't know what he's doing, he's actually out there telling people to misuse this intellectual property reporting system. And I'll talk about that more in a second too, all right? But let me just state my opinion that if you're selling an authorized product, something that you bought from an authorized wholesale distributor or that you obtained legally in any other manner, if you obtained it legally, you absolutely have the right to resell it, okay? Now, where that right becomes questioned is when a marketplace like Amazon gets involved, okay? Bottom line, Amazon absolutely believes in the first sale doctrine. Amazon says if you legally obtain that product, you absolutely have the right to resell it on our site unless Amazon themselves have instituted some sort of brand or category gating that would otherwise restrict you, okay? And then anything you would do to circumvent that, i.e. listing the product under a different category or listing it as something other than what it actually is, then that's a whole nother story. But let's just stick with it for the second with the scenario that you purchased this product legally, right? You have the absolute right, as determined by the Supreme Court under the first sale doctrine, to resell that product. All right, so what's the big deal? Why does this ever become an issue? All right, well, it has to do with the brands themselves, the rights holders themselves. In my opinion, they've received really bad advice over the years, not only from attorneys that don't know what they're doing, big surprise, right? But from these brand integrity police type companies that have popped up over the last couple of years. Because you see, just a little history, hope we're not going down too many rabbit holes here for you, but just a little history is the way a manufacturer used to maintain brand integrity, and by that what they're really talking about is price integrity, is by a MAP program, a minimum advertised pricing program. All right, so they would basically say, hey, you have to sell our product at this price and you can't sell it below. Now the problem is when that policy got challenged in court, and it went all the way, I believe, to the Supreme Court, the court said you can only enforce that MAP policy against your authorized distributors, your authorized resellers. If somebody does not have a contractual relationship with you agreeing to follow MAP, then you can't enforce MAP. All right? This is why I always thought it was so silly years ago when a brand would write me, email me and say, hey, you're selling our stuff, that's great, but we need you to raise the price. And you have to because we have a MAP program. And my response would be, I don't have to. All right. I understand you have a MAP program, but here's your problem. I'm not an authorized distributor. You have no authority or control over me. I can charge whatever I want. And matter of fact, you even trying to get me to change my price is in fact price fixing when I'm not an authorized distributor, trying to influence what I'm charging, trying to get me to collude with you. All right. So that stopped those people from a while, and I was able to sell my products on Amazon. No problem. Then somebody got this bright idea to go around to all of these brands and say, hey, give me like $6,000 and I'm going to change your MAP program to an intellectual property program, right? Okay, so if you're not an authorized seller, which would bring you under the MAP restrictions, you're then violating your intellectual property. What a load of crap. Okay, it's a minor loophole at best, but I think what the brands are going to find out when that gets challenged in a court and goes to the Supreme Court, they're going to lose. And here's why. Okay, when somebody is saying you violated their intellectual property, the only way you can really do that is to be the creator of the content that truly is violating the property. You've taken their photos, you've taken their description off the manufacturer's site, and you're using it to sell something other than the actual product. That's what a true intellectual property violation is, as far as I'm concerned. Okay, again, not a lawyer, just from my experience. Okay, so if you find an already existing listing on Amazon and you find a source to buy that product from, and I don't care where it is, all right, as long as you legally purchase that product, Supreme Court under first sale doctrine says you have the right to resell it on that Amazon listing. UPC code matches, UPC code. Identical product, identical product. Okay? So how is that an intellectual property violation? In short, it's not. In my opinion, it is not in any way, shape, or form. And that's why when this kid, I don't remember his name, Boop, anyway, when he says, oh, when I see somebody on a listing and I don't want them on that listing for whatever reason, I just file an intellectual property violation and I kick them off because I know they're not authorized by that brand to sell that product. Hey, that's wrong. And I'm telling you right now, little boy, if you ever do that to me, you'll find yourself sued. I'll drag you into court for tortuous interference with a business relationship so fast your head will spin because you are misusing the intellectual property system. All right, absolutely misusing it to control the market. So it's restraint of trade, it's tortuous interference. Man, someone is going to hand you your head one day if you do that to the wrong person. And like I said, may all the powers above help you if you ever try to do that to me. Okay. So having said that, why is it wrong? Why is what this kid is doing and telling other people to do and other people are doing so wrong? All right. If a brand, and in my opinion, if a brand has a problem with their product being sold on Amazon, they should contact Amazon and say, we don't want our brand sold on Amazon. You're violating our intellectual property. And Amazon will remove that item from their catalog, no questions asked, because Amazon doesn't want to, as a marketplace, violate anybody's intellectual property. Okay? So then if Amazon, if their terms of service say, hey, if you legally bought that product and there's a page, existing with the same UPC code, same product, go ahead and list it. Why would Amazon say that if they knew it was a potential intellectual property violation? Because it's not, all right? It's not an intellectual property violation to add your offer to an already existing listing, all right? So the companies, right, and these idiot Amazon sellers who are out there telling people to do this don't know what they're doing. They just don't, right? But it is effective, and that's why they're doing it. Because, again, Amazon, they're a marketplace, and they're not going to they try to stay out of the middle, all right? That's why when a rights holder emails them and says, hey, this guy's violating my intellectual property, they don't investigate. They don't look at it. They send you the information and say, here's this guy's email address. We've taken your offer, we've taken your offer off of the listing. Everybody else's is still there. They've taken yours off until you work it out with the rights holder. And when he comes back and withdraws his complaint, we'll be happy to put your listing back up. But that's not going to happen if the whole reason why the guy sent you the intellectual property violation, if his whole reason was to kick you off the listing in the first place, which isn't right, okay? He knows, and here's what makes it even worse, is they know you're not violating intellectual property. They just don't like it that you're not an authorized reseller or that you're below MAP, all right? So in my opinion, and I'm not going to tell you why I have this opinion. Could it have been because I've sued a bunch of brands and won? I don't know. But in my opinion, if you were to sue the person that sent you that intellectual property violation under the scenario that I just gave, you're going to win. You're going to win big, okay? Because what they're doing is wrong. And the people that are out there telling people that this is what they should do, shame on them. Shame on you, Boop. Whatever your name was, all right? Go back to college. Finish college and learn something, okay? Don't come out there with all these suggestions that are just wrong and illegal, okay? So, all right, the real question here now is, okay, so if you get one of these intellectual property violations, what do you do, right? And again, I'm only talking to the people that are truly not doing anything wrong. You bought your product legally. It's the right product. It's on the right Amazon page, and you've put up your offer, and you get one of these intellectual property violations. Okay, well, the first thing you should do is send your invoice directly to Amazon. Now, this did not used to be an option. When this intellectual property violation program first came out, Amazon just said, work it out with them. They didn't even give you the opportunity to send in your invoice. So why'd that change? All of a sudden, why did Amazon start saying, well, hey, if you've got an invoice showing that you legally purchased it, just send it to us. When you send to them the invoice, 99% of the time, they're going to put your listing right back up and they're going to close that complaint because they're starting to catch on to what other people are doing. What these ignorant sellers like Boop, like brands that are coming after you for a MAP violation by sending in an intellectual property violation, they're catching on to that. So they're kind of saying, okay, if you got an invoice, just show it to us. You show us you got an invoice that you purchased it legally, we'll reinstate your listing. And the rights holder is completely left out of the whole thing, all right? So what if you don't have an invoice for whatever reason? What if you send it in and for whatever reason Amazon doesn't accept the invoice? Maybe it's not legible, maybe they just don't like it, all right? Well, then you go to the rights holder. You have an email there. Let's hope it's a good one, because a lot of these idiots use fake email addresses. But let's hope it's a good email and someone's reading it, all right? Your response should be very vigorous, okay? You filed an intellectual property violation against me for a product that I legally purchased, that I have the right to legally resell on Amazon. And you are interfering with my business with Amazon. You might want to even add, I only have 3 of these, and when the inventory is sold out, I'm not going to sell it anymore. Or, you might want to offer them something just because if people are going to do that to you, the bottom line is you don't want to be selling that product anyway. You just want to sell your inventory, be done with it. But you don't want to get stuck with inventory either. And again, if you're really strong-willed and you want to continue selling that on a regular basis, then you're going to have to go after these people hard, okay? Because until there's like actual litigation that goes through the appeals that ends up at the Supreme Court, these people are going to continue to get away with or do this because they're getting away with it, all right? And most Amazon sellers don't have the wherewithal, the resources to sue major brands. I do, okay? So I don't take that garbage from anybody. But usually I can get it resolved short of litigation in most cases. And that's by letting them know you know what's going on, all right? So a lot of times that will resolve it. You just say, look, here's your complaint ID, here's the ASIN, here's the email to Amazon. I need you to immediately contact them now that you know I'm not selling a counterfeit, that I'm not knocking your product off. I'm a really good, legitimate seller. Now that you know that, retract your complaint, withdraw your complaint, put my email in the BCC to Amazon so I know you did it, and I can then not contact my lawyer to tell him to tear you up. All right. So what are some of their potential responses to that? Well, they could say, okay, fine. We see you're not counterfeiting our stuff. So we'll withdraw the complaint. That happens most of the time. Sometimes they'll get really strong-willed themselves, and they'll come back and they'll say, well, because you're not, this should be a whole nother video actually, because you're not an authorized reseller of ours, we're not going to honor the warranty on our own product. Oh my God. Let that sink in for a second. Is that insane or what? They're basically saying, we're not standing behind our product. We don't care where you bought it from. If you didn't buy it from one of our authorized reps, we're not going to honor the warranty. What a load of nonsense. And then they'll use all kinds of rationale like, oh, it has to be kept at a certain temperature, or you need training to know how to handle the product properly. It has to be stored correctly, or it's going to damage the product. And so what they try to do is make this argument that the product you legally bought is now materially different than the ones their authorized reps are selling. Yet if you were to look at them side by side, are they materially different? Of course not. This is all nonsense on their part to control pricing. Remember, this all goes back to their failed MAP efforts. They couldn't get sellers that weren't authorized reps to maintain pricing integrity through MAP. So now they've just shifted gears and say, okay, we're just going to try it this scumbag way through intellectual property, withholding warranties. And by the way, if you do your legal research, there's plenty of case law out there where the courts have flat out said that's illegal to withhold warranty on a product based on where it was purchased from, unless the product has been materially altered, right? So they go after that little tiny hole to jump through, and they start making up all these reasons why the product you're selling is materially altered, right? Because you're not an authorized rep and the warranty doesn't apply, is really their entire reasoning. It's all garbage. And as long as Amazon sellers continue to be pushed around by these brands with these garbage tactics, they will continue to use the tactics. The more people that stand up against them and sue them for this tortuous interference and this restraint of trade, the sooner this practice is going to go away. But they're just like the life insurance actuaries, or actually more like, let's use, because I think this is a real life example, recalls on automobiles, right? The automobile company goes, oh, well, when our car is rear-ended, the gas tank explodes and people will die. But how many people will die, and how much money will that cost us to pay off the dead people versus doing a recall and fixing the problem? Okay, that's all these brands are doing. is saying right now it's economically feasible to harass every Amazon seller who's not an authorized reseller and take the few lawsuits that come at us and settle them. They're still economically way ahead. So we need more lawsuits against the brands and the idiot Amazon sellers that think they're the brand police that are creating these false intellectual property claims. I hope this was elucidating in some manner. If you got questions, feel free to put them in the comments. If you liked it, give it a thumbs up. Go ahead and subscribe to the channel. If you didn't like it, let me know why. All right, peace out, everyone. Take care.